For Creamer Media's Polity, I'm Shannon de Rehove. Norton Rose Fulbright Head of IP Brian Wimpey speaks to us about the government's recent prohibitions on the use of some Rooibos trademarks. Please tell us about recent efforts by the South African government to protect products with the name Rooibos tea. How will the protection of the Rooibos tea trademark be achieved through the recent notice in the Government Gazette?
It's a relatively complicated story. I understand that the notice, the prohibition by government, is as a result of the fact that somebody in France, an unidentified company, has tried to register Rooibos as a trademark, which would give that company a monopoly over the word. In other words, they'd be the only people in France who would be allowed to sell any kind of tea under the name Rooibos. We have an agreement with France, with many countries, called the TRIPS agreement, which should allow us to protect generic terms like Rooibos in other countries. But France's attitude and their interpretation of TRIPS is that we've got to protect it first in South Africa before they will even accept the fact that it is a protected term. Hence the minister's issuing of the notice of prohibition of the use of Rooibos.
Is the trademark now enforceable only in South Africa or also outside of South Africa's borders?
For the very same reason, let me try and correct, it's not quite a trademark, it's a generic term. A trademark gives you a monopoly right. By issuing this notice in terms of the Merchandise Marks Act, it should entitle South Africa to use the TRIPS agreement to prevent registration of the term by individuals or companies anywhere else in the world.
The importance of protecting South Africa's IP is under the spotlight, with a French company wanting to register Rooibos as their intellectual property. Why was this product never registered under IP in South Africa? And what is the current status of this French registration story?
That's a good question. I don't know whether to give you the short answer or the long answer. Let me say the government has not been entirely indifferent to protecting South African terms. About 5 or 6 years ago, the government wanted to amend the Trademarks Act to allow for the protection of traditional terms and expressions. And I suspect that Rooibos could loosely be seen as a traditional term. But the trouble is, there were technical difficulties with amending a Trademarks Act to protect traditional terms, and that amendment has taken years to come through. So I think that's one of the reasons why there's been a gap. Why the government has not previously used the Merchandise Marks Act to issue a prohibition to prevent this kind of thing, I don't know, because it's happened before in the US, in Texas, when a Texas-based company attempted to register, in fact did register Rooibos as a trademark, and it took great efforts and applications brought in US courts to get that person, I think it was Burke International, to cancel the trademark. But you know, there are other things like biltong, for instance, and I was asked the other day, why is biltong not protected overseas? Good question. Maybe there are just things that weren't to the top of the government's head. Maybe they've got other agendas, they've got other things to do.
You suggest a speedier alternative means of protecting the Rooibos brand.
Speedier, no. There are alternative means. My apologies if you got that wrong impression. The speediest is what the government has done now by issuing a notice of prohibition. It's very quick. I mean, he issued it in a matter of days. I think it came out last week or the week before. He gives the public 30 days to complain or object or to comment. If nobody comments or objects, that's it. Nobody can use Rooibos unless it contains the leaves of, or is infused from the leaves of Aspergillus linearis. An alternative, not a quicker one, that our actual Trademarks Act does have what is called a certification mark. So in other words, for example, I understand the wine growers, the pinotage wine growers, may have applied to register pinotage because it's a South African variety as a certification mark, which means that no wine in South Africa can use the brand pinotage unless it's been certified as a genuine pinotage. So government could have gone the route of registering, and I think maybe the Rooibos Council has now in fact applied to register Rooibos as a certification mark. But to get something registered in terms of the Trademarks Act takes 18 months to 2 years. So it's not a quicker method, but it's something perhaps they should have thought of a long time ago. As I mean, the Merchandise Marks Act has protected things like the Springbok symbol, the Red Cross, and so on and so forth.
Can you explain the difference between the two, as well as the procedure for a certification mark?
It's very similar to filing a trademark. You file a trademark application. The difference is that you have to have an organization that is accepted to be able, well, has the authority to certify something. So they have to have a whole set of rules. For example, in the pinotage, they have to say it contains X number, it's this type of grape. Rooibos the same. They'd have to say it has to contain X amount of Aspalathus linearis, etc., etc., etc. So it has to be filed by an organization that does not itself sell Rooibos tea. Okay.
So it's independent.
So it's independent. And then if anybody wants to, and it then has to lodge a set of rules to the Register of Trademarks, and then the Registrar examines the thing in the normal course. There is a slight technicality, I don't know if we want to go into this, is that for a trademark to be registered, it has to be distinctive, namely non-descriptive. So you have this bit of a tension between certification marks and normal trademarks, because certification marks tend to be descriptive. So there is that issue it's got to be, and the best method, as I say at the moment, is the prohibition in terms of the Merchandise Marks Act.
Are there any other developments in the trademark arena that South Africans should be aware of?
Well, I think to go back to the traditional terms and expressions, the government is attempting to protect traditional terms and expressions. And when I say that, it's quite a wide sort of term. It could be anything. It could, for example, this is not really a term, but for example, indigenous painting on a Zulu kraal could be an indigenous painting or something along those lines. But technically, the Institute of South African Intellectual Property Attorneys have objected to the amendment, saying that it doesn't quite fit into the Trademarks Act. And the government's been loath to draft a sui generis act, in other words, an act that stands on its own. It's not necessarily part of the Trademarks Act. And I think that's been the delay. And it's a bit strange because in many countries overseas where the protection of cultural terms and expression is important, like New Zealand, I think they tend to want to draft a sui generis law that not necessarily has to fit into the Trademarks Act. Because of the very tension I spoke about. I mean, a traditional term is descriptive, generally, or generic. Because it's generic, it's descriptive. And you can't register a generic term as a trademark. So there's a tension between cultural terms and trademarks. And I definitely think that cultural terms should be registered, should be protected by its own act, its own law, not the trademark. That's a technicality, but that technicality has led to a delay in protecting this type of thing. And perhaps that's why something like Rooibos or biltong or whatever has not really been protected as yet.
That was Brian Wimpey, Head of IP at Norton Rose Fulbright, speaking about Rooibos tea.